Your Honor, as I said earlier, the husband and alleged victim is in the courtroom. I'm not sure if you wanted to address.
Okay,
We've spoken with him, Mr. Taylor.
Yeah, if he's in the courtroom, I mean, does that change how we're moving forward with the case? This is case 2025 CR 04397, Elizabeth Mascater. Raise your right hand for me, ma'am.
Your Honor, it's a not guilty plea today. If the state
All
has
right.
adjustment to their position in the
All
matter,
right, she's not guilty. Anything else?
I'd request
Interesting.
that bond be reduced. She is currently in custody on a $3,500 bond. Her husband has expressed to the victim advocate that he wants her to come home.
Your Honor, I would object to counsel.
Okay, hold up,
regarding
stop,
the
stop. Okay, first of all, y'all gonna start listening to me and stop interrupting me. Number two, the bond is reasonable for what she's charged with, she's fine. And number three, when do we just drop cases because the victim in a battery case wants to drop cases without first figuring out how far this goes back, whether there's other factors that we haven't considered. Every battery victim wants to drop the case. Every single one, 90% of them. So she's going back with the sheriff. The bond is what it is. It's a not guilty. All right. Who we got there?
If I may have just one moment. So,
Wait, what?
Judge, if I may just have one moment. I'm trying to find out. So, Judge, Ms. Roberts, ultimately, what I may ask is that this case be continued to the next jail calendar.
Well, okay, I'm good. We're gonna continue it.
The issue is just the court's aware, it may be for a non-negotiated plea. Ms. Roberts is currently 8 months pregnant, but there are some issues in this case as far as, and some information I need to find out as far as her custody status. And the recommendation from the state would have her doing additional time. So I just, but I'm trying to find out.
Okay, Mr. Lynch, this is what I know from magistrate court. Pregnant women will fight. They'll fight into their 8th and 9th months. I have seen it. They have come to court. I have had to put them in jail for fighting into their 8th and 9th months. And they're usually fighting over the baby daddy. So, or fighting with the baby daddy. Let me just tell you, her status as a pregnant person has less bearing on this case than anything else, because if she will fight pregnant, she can do jail pregnant. So I'm not pressed about that. What I'm pressed about is, are we moving forward, or is this like they're not giving you what you want? So now you go, I don't care, but if we're going to continue it, let's continue it. If we're going to figure it out, let's figure it out. But the whole back and forth, and I mean, what are we doing?
I understand the court's position. If you could just give me 2 minutes and I'll make an announcement.
Okay. But you know, that whole thing about, oh, she's pregnant. She wasn't too pregnant to fight. Now, I've seen some pregnant women waylay some people. Trust me, 4 years in magistrate court, you see some things. All right. See you in a minute.
Yes, Judge, thank you for allowing me that time. We would respectfully request that Ms. Roberts be placed on next week's jail calendar, and we will likely enter a non-negotiated plea at that time. There is another matter pending before the court that we're also going to dispose of here today pursuant to this plea.
Yes, that is correct, Your Honor. The state intends to null pros case 2025 CR 02419, which is theft by taking, in lieu of Ms. Watts pleading to case 2022 CR 00830. The state's only request, as it has been communicated to counsel, is that part of her recommendation in case 2022 CR 00830 is that she pay restitution back to the business.
And she has agreed to that, and we whatever needs to happen to make that happen, she's agreed to. She can pay it to the probation office. Procedurally, whatever needs to happen, we're in agreement with that.
All right. So what is Ms. Watts going to plead to the offenses before the court for battery, family violence, count 1, battery, count 2, simple battery, family violence, count 3, and simple battery?
Judge, she's going to enter a guilty plea, and she's going to ask the court allow her to take that under the First Offender Act.
Okay.
Your Honor, based upon her criminal history, it appears that she is first offender eligible.
Okay. All right, Mr. Watts, she's entering a plea of guilty to count one or
I
more,
believe count one and
and then the rest will merge?
believe.
Okay. All right, by entering a plea of guilty to count one under the first offender statute, and Ms. Watts, I'm sure your attorney has carefully gone over with you the pros and cons of first offender. The pros are it has a wonderful way of giving you a restart on your record if you successfully complete the terms and conditions of your sentence. The con is this is a one-shot deal, and so this is the one time that you get this reset. So please don't waste it because you'll lose that benefit if you do not successfully complete your sentence. All right.
Yes, ma'am, Your Honor.
All right. Factual basis recommendation, please.
Yes, Your Honor, one moment. February the 2nd, 2022, when officers arrived on scene, they spoke with Faith Williams, later identified as the victim, who stated that her girlfriend, later identified as the defendant, Mr. Watts, had slapped her multiple times. Officers, during the course of their investigation, determined that the defendant did slap the victim multiple times, causing a small abrasion on the left side of the victim's upper lip. Those are the facts of the case, Your Honor, in the amount of $100. Additionally, Your Honor, Ms. Williams is present on the call, on the Zoom call. She would like to make a victim impact statement. In addition, Your Honor, it's my understanding she is requesting restitution.
For what? What's she requesting restitution for, Ms. Ponder?
Your Honor, there are some documents that Ms. Williams sent to our office. I did inquire from Ms. Hemphill, and so I would like for Ms. Williams to be able to address the court on the restitution that she is seeking.
Hey, but here's the thing. This is for battery, so there's no property damage that I heard. What is the restitution for? Is it for medical expenses? What's it for? I mean,
Ms.
we don't just
Are you
free
unable to mute
money.
yourself, please?
It
I'm
was
not-
just for. I'm sorry, Your Honor. I wasn't trying to interrupt.
Can you just raise your right hand? We just want to swear you in. Do you swear or affirm that the information and testimony that you're providing to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down. And as the court had inquired, Ms. Williams, what restitution are you seeking?
Just for what I lost during the situation, there was it was just little small items such as clothes and stuff like that. I ended up leaving a dog cage, and the damages to my vehicle were not during that altercation, but those damages were. I had damage, it was a couple,
Okay,
I had
but-
a standing mirror
Ms.
that was
Williams.
damaged. It was during my stuff being put out.
Okay, but Ms. Williams, that's not what's before me. And what I'm saying to you is the restitution. That's why I was trying to get Ms. Ponder to tell me what this was about, because the restitution, the Roses thing is for the theft case. She stole from Roses, she's paying them back. If there was a fine, I give you damages for that. But the battery thing, unless it's medical, you just give money because you had a bad relationship, she damaged things in the relationship. There has to be a criminal charge attached to that. You got me?
Yeah.
Okay.
Yes, ma'am.
All right. So now, is there anything else that you wanted me to know?
That was it. The court had already addressed it as far as just the no contact.
Okay. All right. So, Mr. Lynch, did you have anything else before I impose sentence and have a few words?
Judge, so I do ask that the court accept the plea as negotiated. She is 26 years old. I believe that this is that she does not have an extensive criminal history or violent charges on her record. And so I would ask that the court grant her first offender treatment. I have explained to her the importance of making sure she gets this taken care of. She knows how important it is to report to probation, and that she gets the family violence intervention program done. And so I'm just asking that you accept it as negotiated and except under first offender. And I just want to make clear, and I believe this is the case, that as far as the restitution to Rosa's, she's going to pay that to the probation office. She doesn't need to make any.
Yeah.
Yeah. We're in
that-
agreement.
I have that in the sentence. I just need to pronounce the sentence. But here's the thing. So Ms. Watts, I'm going to accept your plea of guilty to count 1 under the first offender statute. Counts 2, 3, and 4 will merge. I'll sentence you to 12 months to serve 3 days. Credit for time served. Balance will be probated for you to pay a fine in the amount of $300, 40 hours, and that'll be $444 with the surcharges. 40 hours of community service, a family violence intervention program. That's extremely important to me. It's 24 weeks, it's classes. I need you to take every one of those classes. If you miss more than 3, they'll make you start all over again. You're to have no alcohol or illicit drugs during the course of your probation. You're to have no contact with Ms. Faith Williams in this case. No contact, and by no contact, that means not from a third party, not family members or friends reaching out, no work, text, social media, none of that. Because if you were to have contact with Ms. Williams, you could have the remainder of this sentence revoked, and you could spend the rest of the time in jail. You could also be charged with additional misdemeanors or felonies, including the felony of aggravated stalking, which is punishable by up to 10 years in prison, a $10,000 fine, or both. Are we clear?
Yes, ma'am, Your Honor.
All right. So, and also under the agreed upon negotiated plea, you'll pay restitution in the amount of $100 to Roses, and the address was given earlier. So now, Ms. Watts, let me talk to you. You're 26 years old. I don't know what it is lately about people in these relationships where it's like, I gotta be in this relationship or I'm gonna burn the house down. Everything's gonna go. It's all or nothing. Y'all young people got to learn how to love with love, because nobody wants to be in a relationship with somebody that they're always fighting with. You know, some people think, oh, I'm fighting for my love, and that means I love them hard. There's no such thing as loving hard. That's just crazy. Love should be gentle and protective and warm and caring. And when I walk in my house, I should feel it. I shouldn't always worry about, well, what's going to happen today? Are we going to get into it now? Okay, well, what's this? What's that? Nobody wants that. We clear?
Yes, ma'am.
I want young people to start loving in a way that is actually loving. You know, you don't have to control me. If you feel like you got to look into somebody's phone because you don't trust them, relationship's already over. I'm telling you right now. I hear so many people say, when I search their phone, your relationship's over at the point that you feel you need to search your phone. And at some point, we got to learn, for the betterment of ourselves, walk away. Find your peace, your happiness, walk away. Because nobody wants to. I just did this a couple days ago. Relationship. The guy had gone to the point where he was doxing his former partner, putting his information out on the internet, and doing all. Who wants to be in a relationship with somebody like that? Who wants to be in a relationship where you're punished for being yourself in that relationship? Nobody. So what I ask of you is, if you feel like you start to feel that these things coming up again in another relationship, get some counseling. Because we tend to react the same way in relationships because that's all we know. And we also tend to choose the same people. And if those people aren't the people that are good for us and we keep choosing them, we're going to react in the same ways. You got me?
Yes, ma'am.
Okay. I want you to have good love. I don't want you to have love that ends you up in the jail.
Yes, ma'am.
All right. Okay. So just be mindful that the quickest way to get rearrested and mess up your probation is to not report. So please make sure you report for your probation reports. Also keep in touch with your probation officers. They are amazing at helping to get you successfully through your probation. Okay. They will go to bat for you, but they got to know what's going on. Okay. If you're having any difficulty with the special conditions of probation, and all of these are special conditions, then you got to talk to them about it, okay?
Yes, ma'am, Your Honor.
All right. All right. So when you leave the courtroom, you're going to go out to the right. The courtroom 305, in those first set of double doors coming in, you'll see Miss James. She's gonna be in one of those rooms. If she's with somebody, she'll just ask you to wait out in the hall. But with you, when you speak with Miss James, she's gonna get you set up with probation, okay?
Okay, yes, ma'am.
All right. Now, the other thing I ask is I'm gonna suspend your probation fees for the first month because I want you to pay that Rose's restitution and get that out of the way for the first month,
Yes, ma'am.
okay? And did you have any questions for me?
No, ma'am, Your Honor.
All right. I want you to love the right way. We clear?
Yes, ma'am.
All right. All right. So head on out to get set up for probation.
Thank you, Your Honor.
Thank you.